helped promote this conference, but in particular the Law Society of New South Wales for encouraging lawyers with the lure of CPD points. So I thank you sincerely for coming this morning. I also would like to welcome the participants in today's conference, the Secretary General of the Hague Conference on Private International Law, Dr. Christoph Berlusconi, Supreme Court Judge Justice Robert McDougall, Mr. Ian Coleman SC, Barrister David Hughes, and Barrister Ms. Sandrine Alexander Hughes. Special gratitude must go to Rick Mitri from Mitri Lawyers for his encouragement, support, and sponsorship of today's event. And I also welcome Justice Joanne Harrison, Supreme Court Judge, and Mrs. Suzanne Howarth, lecturer at the University of Canberra and adjunct fellow at Western Sydney University. I welcome you amongst us. For those who I have not met, my name is Shaoquett Moselmane, or Moselmane, anglicised a little. I'm a member of the New South Wales Parliament. I'm the opposition whip in the Legislative Council, and I'm your host for the day, and I welcome you. Today's proceedings will be shared between myself and Rick Mitri. I have the honour of introducing the first two speakers, and then Rick Mitri will take over, will take charge for the rest of the morning. Today's conference is all about the conventions and instruments covered by the Hague Conference as an organisation and its ongoing work, and the Hague Conference on Private International Law and how this all relates to Australia. Currently there are 11 conventions in force in Australia. I won't mention them all, but they include conflicts of law relating to the form of wills, recognition of divorces and legal separations, taking of evidence in civil or commercial matters, recognition and enforcement of decisions relating to maintenance obligations, protection of children and cooperation in respect of inter-country adoption, jurisdiction, applicable law, recognition, enforcement and cooperation in respect of parental responsibility and measures for the protection of children, and finally civil aspects of international child abduction. This last convention on the civil aspect of international abduction is timely. Many of you would remember the case of Miss Sally Faulkner, her imprisonment in Lebanon, and the botched recovery, or should we say, child kidnapping attempt involving 60 Minutes in April of this year. From a legal and, of course, from a parent's perspective, the importance of the Hague Conference on civil aspects of international child abduction cannot be overstated. No one wants to be in Mrs. Sally Faulkner's helpless and desperate position, so much so that she had to resort to a potentially organised, what it was in fact, in many who saw it as an organised crime, kidnapping her own children from a foreign land. The question is how the Convention on International Child Abduction would have helped Ms. Faulkner. Perhaps some of the speakers might enlighten us on this question. Like many countries, Lebanon is not a signatory to the Hague Convention. The only legal remedy available for Ms. Faulkner was to seek proceedings in the foreign country, in Lebanon. How successful Mrs. Faulkner would have been in commencing legal proceedings in Lebanon is, of course, another question. Australia is an active supporter, and perhaps Australia should do more to encourage greater participation in the Hague Conference. I'm delighted this morning to also welcome the Pakistani consular representative, His Excellency Mr. Abdul Majid Yusufani, and his deputy, Ms. Bushra Salam. And I hope they will take this matter and encourage Pakistan into becoming the 82nd member of the Hague Conference. And this is it for me. Time now to introduce our guest. The first guest speaker is Honoured Supreme Court Justice Robert McDougall. Justice Robert McDougall is a judge of the Supreme Court of New South Wales. He was appointed to the Supreme Court of New South Wales in August of 2003, and since then has sat as a judge in the commercial and technology and construction lists. He commenced practice in the bar in 1975 and was appointed Queen's Counsel in 1990. As counsel, particularly since taking silk, and as a judge of the Supreme Court, he has appeared in or presided over some of the most significant civil cases in New South Wales and elsewhere in Australia of the last 25 years. Many of those cases have required the development and implementation of innovative case and documentary management techniques. His Honour is an adjunct professor in the School of Law, University of Technology, Sydney, and lectures irregularly on a variety of topics to undergraduate and graduate students. Please join me in welcoming His Honour to the lectern.
I'm very conscious that I'm not the main act today, so I'll try and be brief in what I have to say, which is why private international law, or as old-fashioned people like me call it, conflicts, is important in this country. Australia is a federal nation. It comprises, relevantly, 6 states and 2 internal territories. There is a national legislature, the Commonwealth Parliament. Each state has its own legislature. Each of the internal self-governing territories has its own legislature. Each of those 9 legislatures has the constitutional power to make laws that govern the rights and liabilities of what one might call their citizens or their residents. As one would expect, there are constitutional allocations and demarcations of legislative power. Although they're of great importance for many reasons, they're not particularly significant for today's purposes. Likewise, the constitutional limitations on the legislative powers of the state and territory parliaments can be put aside for today's purposes. Some people say Australia is an over-governed country, and I haven't even mentioned the 3rd level of government, local government, but the multiplicity of legislative sources is mirrored by the multiplicity of courts. There is a federal judiciary headed by the High Court. The High Court occupies a unique place as the ultimate appellate court for the whole of Australia, and thus a unifying source for Australian common law and the interpretation of Commonwealth and uniform state legislation. It is also the ultimate authority on the interpretation and application of the Australian Constitution. There are other federal courts. There are state courts invested with federal jurisdiction. And those state and territory courts include the Supreme Courts of each state and territory. In those circumstances, it's inevitable that questions arise as to the power of a state or territory court to hear a matter, if it has that power, the body of law that it is to apply, and if it hears and decides the matter, the enforcement of its decision. Those issues were of considerable concern at the time of federation over 100 years ago. That concern reflected the prior independence as separate polities and legal systems of the colonies before federation, and the extent to which the legislatures and courts of each colony sought jealously to protect its rights and revenues. And thus private international law, the system of conflict rules, has always been of central importance in Australia. At common law, the Supreme Court of a state would have jurisdiction over someone simply by virtue of service of its process on that person within the territorial jurisdiction of the court. And conversely, absent some enabling provision, the Supreme Court might not have jurisdiction over someone ordinarily resident there if that person could not be served within the territorial jurisdiction of the court. Almost from the start of federation, there were legislative attempts to rationalise this somewhat strange situation. Pardon me. The Service and Execution of Process Act 1902, a statute of the Commonwealth Parliament, sought to facilitate the service of process issued out of one state court within the territory of another state, or indeed of an internal territory. Perhaps not surprisingly, that legislative scheme was much amended over the years. At the same time, the statutes and rules of court that to a greater or lesser extent govern proceedings in individual courts sought to define the circumstances in which there was a sufficient connection between a cause of action and the particular court, so as to justify service outside the jurisdiction, or what is sometimes called long-arm jurisdiction. As Australians became more familiar with the fact of federation, and accustomed to think of themselves as Australians rather than as citizens of a particular state or territory. One might observe there are still a couple of states in which that process is a way to develop. There were increasing legislative efforts to facilitate the work of the courts in dealing with disputes that were properly before them. Likewise, as trade and commerce grew, particularly having regard to Section 92 of the Constitution, intra-national disputes flourished, and the legislatures of the Commonwealth, the states and the territories responded in kind. In part, no doubt, those developments reflected Section 118 of the Constitution, which requires that full faith and credit be given throughout the Commonwealth to the laws, the public acts and records, and the judicial proceedings of every state. Section 118 has been given a somewhat limited interpretation, but that's not to the point for today. One important legislative device for managing conflicts has been the uniform scheme for cross-vesting of proceedings from the courts of one state or territory to the court of another state or territory, where it is in the interest of justice to do so. The interest of justice have been interpreted by the High Court as meaning that the case should be heard by the court of the jurisdiction that is the most or more appropriate or natural forum for the resolution of the dispute. A decision on that question involves a nuts and bolts analysis of the connecting factors between the litigation and the jurisdiction in which it has been commenced, and between the litigation and the jurisdiction to which it is sought to cross-vest it. In the printed version of this paper that I will provide to our host and that will be available for distribution once I've corrected a few of the things that I see on the way through, I describe a particular case, Perrott and Robinson, which exposes some of the problems of conflicts that arise. I won't take up time by doing that now. Ultimately, in that case, the High Court concluded that the law of the place where the wrong occurred should govern the substantive rights of the plaintiff, notwithstanding that there were valid connections to other legal systems. It is quite clear that the High Court's decision was informed by the important policy requirement of preventing forum shopping, of preventing a person from going from jurisdiction to jurisdiction to try and get the legal system that would facilitate the most favourable outcome in terms of damages or compensation. It was rather a strange result in some circumstances, and again I go into that in the paper. I won't take up time dealing with it now because I realise there are people who you would much rather hear. I don't want it to be thought that litigation in this country is beset by conflicts of laws problems. It is not. But despite the best efforts of the legislatures to ensure that such problems are minimised, they do exist. Now, so far, of course, I've only talked of conflicts problems arising within Australia. Australia is an island nation, one that has close trading ties with many countries around the world. Inevitably, trade and commerce being what they are, disputes will arise between trading partners. Thus, conflicts problems can arise at the transnational level. Does a court of a state or territory in this country, pardon me, or a federal court have jurisdiction? How can it assert that jurisdiction? How can any decision in favour of the domestic plaintiff be enforced? Similar questions will arise when litigation is commenced in the courts of another jurisdiction and the successful plaintiff seeks to recover the fruits of its success in Australia. Those problems and others were addressed in the courts of another island trading polity, the United Kingdom. From the 18th to the 20th century, English, as they mostly were judges, grappled with the problems raised by transnational trade disputes. They developed an extensive body of rules. Those rules addressed each of the three stages at which conflicts of laws can arise: service, choice of law for resolution of the dispute, and enforcement. That body of law has in equal degrees fascinated scholars and tormented students over the decades. Now, many aspects of transnational conflicts problems are the subject of international conventions arising out of the work of the Hague Conference. We are fortunate to have someone of Dr. Bernasconi's eminence to address us today on the work of the conference. I shall not embarrass myself by seeking to summarise or predict the topics that he will address. I will simply say that I'm very glad to have the opportunity to hear him speak. About to do a runner.
Yeah. Before he's on a runner, I wanted to present him with a token of our appreciation with a pen of New South Wales Parliament.
Thank you very much.
Shaoquett, excuse me, a little bit that way, please. Yeah. Thank you. Thanks very much.
Thank you.